afternoon, Your Honor. Daniel Magoo.
All right. Mr. Gu, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor and or felony, punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself. In this, you have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If for whatever reason during any point in this proceeding you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum.
Mr. Msur is back in court, and this time he's about to realize why walking in without a lawyer is a huge mistake. If you're new here, this video continues from one I made earlier about him. Honestly, Daniel Msur doesn't take anything seriously. He refuses to answer Judge Simpson's questions and acts like he's smarter than everyone else. From the beginning, things went badly. He even walked into court chewing gum with no attorney to back him up. That's a terrible move. Guys, don't ever copy this. Having proper legal help in court is essential. Anyway, let's jump in and see what happens between Msur and Judge Simpson this time.
And
Thank you.
so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or prelim.
You wish to have a preliminary examination?
Preliminary examination, yes, sir.
But do people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals of the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed include appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping that we can sort of reconcile both of those things as whether or not discovery is something the defendant prepared to move forward, and if he ever intends to file a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Magoo, your response?
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong, as far as anything that they've submitted. So if it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motion, We will hear the motion or the motion will be heard on date of exam.
Thank you, Your Honor.
Deal with it at that point in time. So the people would have their witnesses available on the second.
We can try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025. 12.
Yeah.
12 noon, that is before me.
Thank you, Your Honor.
And continue.
This is a perfect example of why you should never try to defend yourself in a serious case. Not only does this guy show up without a lawyer, but he's also arrogant and tries to go head-to-head with the judge. Honestly, I don't know what he was thinking. He even comes across like one of those sovereign citizens I've talked about before, the kind who always act like they're above the law. The problem is, he's not facing something small. He's accused of assaulting a police officer. Because of that, he also lost custody of his child. That doesn't just happen for no reason. It's a huge deal. But instead of showing any concern, he treats the situation like it's nothing. The judge clearly can't stand him, and honestly, I think most viewers feel the same. This just proves how badly representing yourself can backfire. In the end, you're only making your own situation worse. And losing his child shows just how serious this really is. He seems unstable, irresponsible, and definitely not someone who should be handling this on his own. That's all for this part. His next court date is in January, and I'll be covering it when it happens. It's going to be interesting for sure. If you enjoyed this breakdown, please like and subscribe. It really helps. Thanks for watching and take care.